So, we know that environmental impact assessments, EIAs, are formal processes that look at the kind of harms or other outcomes, positive or negative, that could happen from a major project. Pollution, jobs, explosions, whatever. Today we're going to look a little bit at the EIA in environmental law, particularly international environmental law. I think that I may have rambled a little bit about this when I introed international environmental law earlier. I don't remember. I'm sorry. Whatever. We're going to ramble it again about it more now that we're talking about EIAs specifically. And eventually I'll talk to you about why I'm talking about an EIA. I think I've mentioned it again vaguely a couple of weeks ago when I was talking about what I was doing this summer. Anyway, EIAs in international law, you are required, you being the state, because that's the only thing that actually really has any kind of formal weight in international law, to conduct an EIA when there's some kind of activity that will take place with the potential for international transboundary harm. That's a nebulous issue, because of course everything has the potential for harm. My sitting here has the potential for harm, have we watched that movie, The Butterfly Effect, or whatever. So things impact each other, right, and we all create harm. Every factory that's created, every car that's driven, impacts and adds to climate change and the greenhouse gas effect and things like that. Obviously, international law does not actually require an environmental impact assessment every time you drive down the street to get groceries. Maybe it should. I don't know, what kind of groceries are you getting? However, for things that are obviously have the potential for transboundary harm, an EIA is a pretty unilaterally agreed upon requirement now. It started in a case on pulp mills and has been reiterated in a lot of international decisions since, and more conventions and international agreements, that some of whom have full legal standing in international law, others of which are more soft law, agreements that not all countries have signed on to or that may not have explicit teeth, but certainly inform and influence the way international law is seen and understood. So if, for example, you build a factory really close to an international boundary, right, where pollution is likely to waft over, drain over or whatever, be it land or air or sea, river, or whatever, into another country's borders, right? That's fairly obviously a potential for transboundary harm. You have to figure out what kind of pollution is going to get over there, what the impacts are going to be, how you could help mitigate those. More and more legislations are calling, for some kind of consultation and negotiation, calling up your neighbor country on the phone, being like, yo, really need this factory to be here. Here's what's likely going to happen. Here's a wee bit of compensation, right? Let me know if we need to come to a cleanup, that kind of thing. Supposedly this is all very friendly, of course, and it happens, things like that. There have been cases, not all of them have made it all the way to court. The idea of law is that most of these things then actually don't get sued, right? Because governments, their advisors will look at the law and say, look, you have to do this bit, right? And if you don't, the other party will win and you'll get sued for, way more. So just, pay them off now or whatever. This is not a very glamorous view of things I'm giving. Anyway, so step one is that if, there's some kind of activity taking place that hasn't had an EIA done for it, do it. Ask the state to do it. If a state is participating in some kind of policy or program that is likely to produce transboundary environmental harms and they haven't done an EIA, you can ask the International Court to require them to do so. And that has happened in the land reclamation case at the International Tribunal for Law of the Sea. Yay! Anyway, so it is possible. And EIAs are increasingly a requirement that are brought up in the Rio Declaration and tons of all kinds of environmental law cases, but then also, more and more explicitly, there is a specific agreement around EIAs and what all an EIA needs to encompass and that kind of thing. So more and more attention getting and trying to figure out and mitigate so that we know, and can avoid future climate change and, things of that nature.